So good morning, everyone. My name is Amanda Ridding. I am doing my second video with respect to motion to quash versus motion to withdraw or dismiss. It's August the 12th, 2022. Yesterday I was in court, and the first video gives sort of a backstory as to what was going on with respect to motions to motions to withdraw or dismiss that were filed on May the 18th, heard on June 8th, 2022, and then were elevated to judicial review on July the 25th, 2022. So when we got to the hearing on July 25th, 2022, the court informed us that they were dismissing the review, lack of jurisdiction. But even in that instance, the Superior Court of Ontario tried to change the nature of the claim and making it about the fact that we hadn't yet had a conviction for a trial, a substantive decision in the case. And he was trying very carefully to stick it to that wording, not mention the word trial, but to say it's a substantive issue in the case implies that we need to have a trial first, which means even the judge and it is a judge at the Superior Court of Ontario, even the judge is complicit in this matter of creating a false pretense as to why he was giving dismissing the judicial review. So his dismissal of the judicial review, lack of jurisdiction, the ruling is correct, but the grounds of the ruling was false. Okay, the reason why he didn't have jurisdiction is because we never had jurisdiction on June 8th, and he should have the competence in law to know that and then to express that. Instead, he changed the nature and made it about the fact that we hadn't yet had a trial, which would then be a matter for an appeal. And that is an act of deceit with the intent to misrepresent or misconstrue the law to get the defendants to believe that they have to either go back to a trial or elevate it again. And these acts of the courts have got to end. So on August the 2nd of last week, I was trying to decide whether, I was helping somebody. They called me and asked me to look at their motion to withdraw or dismiss. And I said, well, what rule are you using? And he said, I don't know. So we went to the Provincial Offences Act. And while I was helping somebody else find the rule for the very motion I had done on June 8th, it became apparent that there is no rule for motion to withdraw and there's no rule for motion to dismiss. And as I'm telling you, law is positive. In absence of a rule to move the court has no authority. And so therefore, in absence of a rule for a motion to dismiss, in absence of a rule for a motion to withdraw, court doesn't have the authority to grant your request. Okay, the rule has to exist in order to have the court to have the authority. So I realized that what we needed to do was neither dismiss or withdraw. Going through the rule book with this other person, we discovered that the rule is motion to quash. We need to quash the information. And if you quash the information or you quash the certificate, it's gone. It's done. It's all over. It's not clear and regular on its face. You want to do a motion to quash. It's not clear and regular on its face. Therefore, the information is gone. It's quashed and there's no more case. Okay. Easy peasy. Rule 36, subsection 1, Provincial Offences Act. So that was on August the 3rd. On August the 2nd. On August the 3rd, I resubmit those motions. I actually verified it with an attorney in law, not personally, but through a friend. And the attorney at law confirmed that if the June 8th motions were motions to withdraw or dismiss, then I'm correct. The court does not have the authority to make a ruling, and therefore it is as if it had never been before the court. And absolutely, you can do it again using the correct rule, which is a motion to quash. So we resubmitted the motions. This time we submitted motions to quash pursuant to Rule 36, subsection 1 of the Provincial Offences Act. And then I put in with it the following letter, and I've changed the letter for personal privacy, but I'm going to share the letter here. All right. So the letter says, to all parties acting in the name of Her Majesty the Queen, which establishes legal authority of federal jurisdiction. And that comes from the preamble and Rule 3 of the Constitution Act of 1867. This is going to Joe Rockhead, the municipal law enforcement officer, the Crown Attorneys in the Crown Attorney's Office at Bedrock, and the Ontario Court of Justice at Bedrock. Notice of failure to meet standards of professional conduct. So I'm calling them out here. It has come to the attention of Fred Flintstone and Pebbles Flintstone, the defendants, that the motion to dismiss presented on June 8th lacked jurisdiction. The motion was not properly before the court. Through an act of nescience, and nescience means they had no knowledge. It's not that there's knowledge there and they ignored it. They had no knowledge. Through an act of nescience, the defendants did not know nor follow Rule 36, Provincial Offences Act. And I had a typo there, so it's supposed to say POA, not POS. So there you go. To move the court to quash the information. It has come to the attention of the defendants that the court does not have the authority to act on a motion to dismiss, as no such rule exists under the POA. It has come to the attention of the defendants that only the grounds within the court's authority to dismiss was lack of jurisdiction, as no rule exists to allow the court to move in any other way. The court's ruling lacked therefore the court's rulings lacked jurisdiction. Due to the fact that defendants' motions have never been properly before the court, they technically do not exist, nor does the court's decisions. On August the 11th, 2022, the defendants are each submitting 3 motions to quash the information pursuant to Rule 36, Provincial Offences Act. The information is not clear and regular on its face. Under the provisions set out in the Constitution Act of 1867 and limited by the quasi-constitutional Canadian Bill of Rights 1960, the defendants demand that any intent to argue the defendant's motions be put before the defendants by notice of motion no later than 5 p.m. on August the 9th, 2022. All parties have been made aware that the defendants are pro se defendants. All parties have been made aware of their fiduciary duty of the law, duty to assist unrepresented defendants. R versus Canoon, 2018, from another referenced case law, Her Majesty the Queen versus Ridding Salamander Opportunities Incorporated, 2019, Ontario Court of Appeal. Everyone acting in the name of Her Majesty the Queen has a duty to inform and or assist anyone not following the rules, and, when directly asked, to inform the one asking the rules of law, which the defendants in this case did ask. They asked for the rules and were denied, absolutely denied. From the perspective of the defendants, all parties knew that this motion lacked jurisdiction on June 8th, 2022. From the perspective of the defendants, the Crown Attorney's Office has acted dishonorably with their willful acts of withholding knowledge of the rules of law to the prejudice and detriment of the defendants, contrary to Rule 5.1-3, Rules of Professional Conduct. These are the rules that govern the lawyers, folks. You can find it under the Law Society of Ontario. The defendants are and remain part of the public to whom the prosecutor holds an obligation of fiduciary duty to. From the perspective of the defendants and confirmed by an attorney at law, the motion presented on June 8th, 2022 does not exist, as jurisdiction was lacking and apparently confirmed by the email received from the Crown Attorney's Office on July 15th, 2022. From this moment going forward, anyone using any act of syllogism to pervert the rule of law and or pervert the judicial proceeding will be deemed by the defendants as an actus reus to pervert the course of justice and or judicial proceeding and may be held personally liable. From this moment going forward, anyone using any act of subterfuge using common case law to subvert any rule of law in violation of Rule 96.2, Rules of Equity to Prevail Courts of Justice Act, will be deemed by the defendant as an actus reus to pervert the courts of justice and judicial proceeding and may be held personally liable. I should stop there for a second because I actually misquoted which rule book that falls under. So Rule 96, subsection 2 actually falls under the regulation under the Courts of Justice Act, and it's the regulation for the Rules of Civil Procedure that I pulled that from. So my apologies. To understand these motions, it is not necessary to begin at the root. To understand these motions, it is necessary to begin at the rule of all law of Canada. Everyone must first understand the nature of the provisions set out under the Constitution Act of 1867, under which all parties involved gain their federal legal authority. The Constitution Act 1867 is the supreme law of Canada, which no statute, regulation, or common case law can supersede, and the defendants have the lawful right to invoke the Canadian Bill of Rights 1960 at any time to limit any agent of the state from infringement, abridgment, or abrogation of the defendant's recognized and protected human rights and fundamental freedoms. Rules of equity to prevail, Rule 96, subsection 2, which should say rules of civil procedure under the Courts of Justice Act, which I've made an error there. Again, I've had lots on my plate lately. Where a rule of equity conflicts with the rule of common law, the rule of equity prevails. When case law is in conflict with the rules of law prevail. No more judicial activism. The defendants demand the court follow the rules of law. And then I quote the judicial conduct principles of judicial office directly from the website. Under judicial conduct principles of judicial office, Rule 1.2, justice of the peace have a duty to follow the law. Rule 2.2, justice of the peace should conduct court business with due diligence and dispose of all matters before them promptly and efficiently, having regard at all times to the interests and justice and the rights of the parties before the court. Canadian Bill of Rights 1960. And Rule 2.4, justices of the peace have a duty to maintain their professional competence in law. Remember what I said about competence? When you engage in a motion that they don't have authority for, and then you rule in that motion, then you are not displaying competence in law, are you? And then for the Law Society of Ontario, here's where you can find the rules, folks. I've got it posted right here under the rules of professional conduct, Rule 5.1-1. When acting as an advocate, a lawyer shall represent the client resolutely and honorably and within the limits of the law, while treating the tribunal with candor, fairness, and courtesy and respect. Rule 5.1-2. When acting as an advocate, a lawyer shall not abuse the process of the tribunal by instituting or prosecuting proceedings which, although legal in themselves, are clearly motivated by malice on the part of the client and are brought solely for the purpose of injuring the other party. B, knowingly assisting or permitting the client to do anything that the lawyer considers to be dishonest or dishonorable. Don't forget, the Crown's representing Her Majesty the Queen. Don't you think you should be telling the Queen you shouldn't be doing things that are dishonest and dishonorable? Knowingly attempting to deceive a tribunal or influence the course of justice by offering false evidence, misstating facts of law. Oh my God, she engaged in a motion that had no authority. That's misrepresenting facts of law, presenting or relying upon false or deceptive affidavits, suppressing what ought to be disclosed, which, by the way, the Crown's done that too, or otherwise assisting in any fraud, crime, or illegal conduct. And folks, look up the definition of fraud, because when you deceive somebody, that is an act of fraud. Rule 380, Criminal Code of Canada. Knowingly misstate the contents of a document, the testimony of a witness, the substance of an argument, or the provisions of a statute, or like authority. So they're doing all of this. Look at what they do with Rule 136. Knowingly assert as true a fact when its truth cannot reasonably be supported by the evidence, or as a matter of which notice may be taken by the tribunal. Knowingly misrepresenting a client's position in the litigation or the issues to be determined in the litigation. Look at all the rules that are being broken by the lawyers, guys. Learn the rules, call them out on it. Rule 5.1-2A, a lawyer shall not counsel or participate in the concealment, destruction, or alteration of incriminating physical evidence or otherwise act so to obstruct or attempt to obstruct the course of justice. These lawyers are obstructing the course of justice. Rule 5.1-3, when acting as a prosecutor, a lawyer shall act for the public. Guess what, folks? The defendants are part of the public. They have to act on the defendant's behalf as well. This is where I keep bringing it back. They have a fiduciary responsibility to the defendant as well. They're the prosecutor. They have to act for the public and the administration of justice resolutely and honorably within the limits of the law while treating the tribunal with candor, fairness, courtesy, and respect. Rule 5.1-5, a lawyer shall be courteous, civil, and act in good faith to the tribunal and with all persons with whom the lawyer has dealings. Now, I have to keep these clips short because I don't pay for YouTube subscription. So I'm going to stop here and say, please watch the third video because I want you to see what came next. And then I'm going to tell you the conclusion of this story. Thank you so much. And I appreciate everybody who is watching these videos and who is helping me get these videos out. I am asking people, if you think this information is valuable, if you think what my journey, what I'm sharing of our journey is going to help you and other Canadians, please like, subscribe, and share. Get this information out there. I do it solely to help my fellow Canadians because I am a proud Canadian. Thank you.